Hello and welcome to the session on legal responsibilities. My name is Michelle Cowan and I'm Academic Lead for Disability and Dyslexia in the Faculty of Health Science at the University of Southampton. The aims of this session are to provide you with an overview of recent legislation which relates to disability and inclusion, but much more importantly than that, to explore the implications of this legislation and really think about the need for reasonable adjustments and how we balance that with professional standards. Until recently, the Disability Discrimination Act of 1995, which was later revised in 2005, has been the main piece of legislation. When it came out, this made it unlawful to discriminate against anyone suffering from an accepted disability on the basis of that disability. In April 2010, the Equality Act was passed, and this came into effect from the 1st of October 2010. In legal terms, this is classed as a consolidatory act, which means it's going to replace all of the previous legislation related to diversity, equality and inclusivity. In effect, everything that's existed before on issues such as race relations, sexual orientation, disability and other associated legislation will now be replaced with the Equality Act. The Act introduces some new concepts, and the first of those is something that it calls a positive duty. The Act was drawn up by the previous government, and they really wanted to strengthen the requirement to be proactive and prevent discrimination before it happened. Although the main aspects of the Act came into effect from October 2010, the duty to promote came through a little bit later, in April 2011, and we're only now really thinking about the implications of that. Another key feature of the Act is to introduce an anticipatory duty, and that links very closely with the positive duty and asks us to anticipate the need for adjustments and have them in place without necessarily needing to be asked for them. So a good example of that would be providing disabled toilets in all public places and making sure that buildings have ramps and things like that to accommodate anyone who needs it without them having to ask. For universities, it would include things like creating an assessment strategy which is dyslexia friendly and would take into account different types of assessment that suit different learning styles. It also looks at the implementation. So exam papers need to be produced on cream paper or off-white coloured paper in a dyslexia friendly font and need to have been reviewed in advance to ensure that the language is appropriate and will meet the needs of students with dyslexia. The same principles apply to anticipating the need for adjustments in practice settings, and there are some sessions that follow this one which will really help you to identify the adjustments that might be needed by different types of student. We need to think about what we mean by disability, and the Equality Act has defined it as any condition which has a significant, adverse and long-term effect on the person's ability to carry out everyday tasks. If we just unpick that for a moment, there are some key words in there. Significant on its own is fairly self-explanatory, but it's important to recognise there are a couple of conditions, HIV, multiple sclerosis and cancer, all of which are covered from the day of diagnosis. They don't need to be having any effect on the individual at that point in time for the person to be protected by the law. Long-term is another key word that comes into the definition, and there they're looking at conditions which last a year or longer. The other thing to consider is the effect that something's having on the person's ability to carry out everyday tasks. Looking at that definition, I wonder if you can think of any students that you've been involved with who would have something that would meet this definition of a disability. You may have come up with all sorts of different things, and this list just identifies some of the conditions that I've had experience of supporting students with. So mobility difficulties could cover students with a limp. It could also include students who are wheelchair users, and could include students who have had an amputation and have mobility difficulties as a result. In terms of visual impairments, we encounter a lot of students nowadays who have different categories of visual impairment, maybe from an altered field of vision to having an eye missing or being blind in one eye. Hearing impairments, I think, are fairly self-explanatory. Autistic spectrum disorder is one that's really started to emerge over the last few years, in that more and more students are coming forward who are on the autistic spectrum. It has to be remembered that this is a spectrum and that we're looking at a very wide continuum in terms of the amount of effect it will have on the student. It may be that the student is able to communicate effectively in most situations, and it's certainly not an automatic barrier to being able to come onto the programme. We encounter students with unseen disabilities, for example, epilepsy and diabetes. We're often not told about these students because the student may not see it as a disability themselves or feel that they need any support in managing their condition. But under the terms of the Equality Act, they count as a disability, and we may need to be aware that the student needs some help. Students with mental health difficulties form the focus of one of the presentations on this DVD. There is also a presentation, in fact there are two presentations, looking at specific learning difficulties. That includes conditions such as dyslexia, dyspraxia, attention deficit disorder and dyscalculia. And we've split the presentation so that one part gives an overview and the other focuses on strategies that you can use to help students. The final type of disability that I've identified here are latex type 1 allergies. Of course, there are lots and lots of other conditions, and it's a case of going back to the definition and deciding whether something meets that definition of a disability, which means by law we're required to support the student. That leads quite nicely into thinking about how we support students and reasonable adjustments. Under the terms of the Equality Act, students are entitled to receive reasonable adjustments to help them overcome their difficulties. Students with a disability must demonstrate, however, that they are fit to practice and they're expected to meet all of the learning competencies and skills that other students are required to do. The key factor is that the adjustments have to be put in place before you can assess competence. In terms of what a reasonable adjustment is and when something is unreasonable, it's quite difficult sometimes to decide. Legally, there is no definition of reasonable, and it's down to an individual or organisation to decide if they feel that something is reasonable or not. However, just a word of warning, there's a chance that these decisions will need to be defended in court, and there are some tests of reasonableness which might help you when you're making a decision. The first one of these is to think about how effective the adjustment would be. If an adjustment is deemed as being effective in preventing or reducing disadvantage, then I think most people would consider it to be reasonable. How practical something is, whether it's actually easy to implement, is a key feature. If something's seen as being very easy and straightforward to put into place, then I think it would be very hard to defend a refusal to do so. When it comes to costs to the individual or organisation, these take into account things like financial costs and also disruption. It may be that employers or organisations are reluctant to put things into place that they feel are quite expensive. But again, a word of warning, there are a group of people called the Office of Independent Adjudicators, and if a student feels that they have been disadvantaged, they are ultimately the people the student will complain to. The Office of Independent Adjudicators view the NHS and universities as being relatively rich organisations, and they would argue that it would actually be inappropriate and unreasonable of us to contest a student's request for reasonable adjustments on the basis of cost in most circumstances. The final test of reasonableness, which overlaps a little bit with the last one, is about the size of an organisation and its resources. And it might be worth thinking about that in relation to things like student support. Certainly, if a student wanted extra time to be spent with them to go through things, if it's a large organisation and there are a lot of staff, then that would probably be seen as being very reasonable. If someone's working much more independently, it may be more difficult to do, and it may be easier for the person to argue that it's not possible. There are just a few examples here of things that we've put in place as reasonable adjustments. Provision of an augmented stethoscope is a relatively easy task. Later on, there's a presentation which looks at supporting students with physical disabilities, and it gives a lot more advice about how to help students with hearing impairments. It's really important that the correct stethoscope is purchased, something that's compatible with the student's hearing aids. But certainly the idea of providing a stethoscope or a telephone to support a student with a hearing impairment is something that I would consider to be very reasonable. Students with dyslexia or visual impairments may benefit from coloured overlays or magnifying overlays. A lot of students benefit from having additional skills rehearsal time to be able to practice and find their own way of doing something in an unrushed and unclinical setting, maybe in a skills lab, or maybe when they're out in practice. It's just that they need a little bit more time to really gain their confidence. Seating arrangements in key meetings may need to take into account people with hearing impairments who may want to sit in the front, or other types of disability. Some students will want to negotiate shift patterns. They may find it very difficult to work certain shifts, for example night shifts, or they may want to work slightly shorter hours or shorter days than their colleagues, and this is something that needs to be considered as a reasonable adjustment. The student may be making a request for something that you consider to be unreasonable, but it's the fact that you've actually considered their request and given them a rationale as to why you're willing to support it or not that's important. Car parking on site, particularly important for students with mobility problems, and the use of assistive technology is something that's widespread amongst a lot of students with different types of disability. Of course, before we can put in place any reasonable adjustment, we need to know that the student needs them. And one dilemma that students often face is whether or not to tell other people. Some disabilities are immediately obvious. For example, a student with mobility problems, such as a limp, it may be very difficult for them to hide their disability. Other types of disability are hidden, and unless the individual chooses to disclose them, nobody would know. Legally, if a student has told one person within the organisation as a whole is viewed as knowing. So if an organisation has not put in place reasonable adjustments, they won't be able to argue that they didn't know the student needed them if one person did. Looking at why students disclose, employers have got a legal obligation to provide support, but can't do so if they don't know. So disclosure enables reasonable adjustments to be made and support mechanisms to be put in place. Disclosure also encourages communication and improves workplace partnerships between the student and their supervisor. If a supervisor understands why a student is having a particular problem, they're often much more motivated to help find a solution, and that's certainly a reason why I would encourage students to disclose wherever possible. There are reasons why people choose not to disclose. Some of these come out later in some of the other presentations, where students are talking about their own personal stories. Students may fear being labelled, and they may be worried about discrimination, and who's going to hold on to that information and how confidential it will be. They don't want the world and his wife to be told about something. It's very personal to them, and under the Data Protection Act, it's defined as personal sensitive data. They may not like admitting to having a difficulty. And then finally, but a very common reason, is that students feel that they have very good, effective coping strategies and they don't need any help, so they don't need to tell people. What we need to do is to ensure that there's an inclusive culture where students feel able and willing to disclose to people. So if we look through the student journey, we need to raise awareness so that we can create a culture where people feel it's free from discrimination and where there's a supportive environment which supports individuals and their particular learning differences. We also need to provide an environment which supports individuals to make the right career choices to aid success. Sometimes we need to gently guide students in another career direction. The reason for this is it's often linked to professional standards. And one thing we need to do is to debate the challenge of how we balance reasonable adjustments and maintain professional standards, and that links very closely to fitness for practice. So in conclusion, educational providers and our practice partners have got a legal and moral responsibility to guarantee that all students are not disadvantaged, irrespective of any disability. But this does create a professional challenge. We need to make sure that students receive a high-quality education in theory and while they're out on practice placements. This should be meeting all of their individual needs, but maintain academic and professional standards. Hopefully, this session has raised your awareness and understanding of what your legal responsibilities are and will underpin the information contained within the other presentations. This last slide just gives you some ideas of areas you could find more information about. There are further reading resources available in the booklet which accompanies the DVD. This includes work by the Health Professions Council and the Nursing and Midwifery Council, who have both published information looking at the support they feel is appropriate for a student with a disability entering one of their programmes. And it's certainly something I would recommend you explore further.